All right, are you Lindsay Hornsby appearing there on the screen marked M. Parker?
Yes.
All right. This is case number 23, CR 220, State of Ohio versus Lindsay Hornsby. Ms. Hornsby is appearing from, where are you at, the counseling center?
Yes.
The counseling center. This hearing has been conducted by Zoom. Her attorney is Danielle Witt, appearing from her office. Appearing on behalf of the state is Assistant Prosecutor King. The defendant is charged with possession of a fentanyl-related compound, a fifth-degree felony. This matter was set for a plea here this afternoon, and since Ms. Hornsby was in the treatment facility in TCC, it was set by Zoom. And Ms. Witt, you and your client both in agreement this matter can be conducted by Zoom rather than an in-person appearance in the courtroom.
Yes, we are.
And you're all right with that, Ms. Hornsby?
Yes, sir.
All right. Now, if at any time during this proceeding you need to talk to your attorney, just let me know, and I'll put you and her in the breakout room. It will be just the two of you on the screen, and no one else will be able to see you or hear you, okay?
Okay, thank you.
All right. Now, Ms. Hornsby, I've been presented with a plea of guilty form. It's kind of darkened, probably from the facts, but it has a couple of original signatures of the attorneys. And I'm going to hold this first page up to the camera first. It has the date, it has the case number, your name, plea of guilty form. You see that there?
Yes.
All right. And you recognize that?
Yes.
All right. On page 3, there is a sentence that reads, I enter this plea voluntarily, and immediately below that appears to be a signature of Lindsay Hornsby. I'll hand that up to hold that up to the camera. Is that your signature there?
Yes, sir.
When did you sign this document, Ms. Hornsby?
Oh, gosh, I believe when I was in store.
All right. And when you signed it, did you understand that it was an agreement to plead guilty, which means there would not be a trial, and the next step would be a sentencing hearing?
Yes, sir.
And had you talked to your attorney and had her explain everything for you before you signed it?
No, but I wasn't aware of what was going on. It was explained to me.
Okay, you discussed the terms and everything and what the agreement would be.
Yes.
All right. And so you have, you feel you had enough time to fully consider the matter before making this decision?
Yes.
And did you sign this agreement voluntarily?
Yes.
And since it's been a while since you signed it, is this what you still want to do?
Yes, sir.
Okay. And you're entering into this agreement to plead guilty today and going forward today voluntarily?
Yes.
Right now, the agreement is that you're going to plead guilty to the charge of possession of the fentanyl-related compound in violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony. Further states that you understand that this offense could carry a penalty of 6 to 12 months in prison, a fine of $2,500, and a license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
And other than the charge you're on probation for now, for which you were in STAR, are you facing any other felony charges?
No, sir.
And are you on probation for any other offenses other than the one you're currently on for?
No, sir.
Okay. Now, in the event that you should be convicted in the future, or convicted of this offense and given community control, and if your community control should be revoked in both cases and you're ordered to serve a term of incarceration, those sentences could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes, sir.
Now, you're not under post-release control or parole for anything? All right. Now, under the law, should you go to prison for this offense, upon completion of that term, it is possible Adult Parole Authority would exercise the option under the law, put you under what's called post-release control for a period of up to, for a period of up to 2 years, which means that you would be supervised by a parole officer on the terms they set, and if during that period of time they determine that you had not complied, then they could return you to prison to make you serve an additional period of up to half of the prison term for one or more violations, but and that's also the cap for all violations. However, should you be convicted of a new felony, Then in addition to whatever sentence the judge in a new case can impose upon you, that judge can also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that could be, would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes.
Under the law, I'm not required to sentence you to a term of incarceration for this offense. I can impose what's called community control or probation. And that means that instead of going to prison, you'll be put under the supervision of a probation officer in a term set by the court for a period of up to 5 years. And if during this period of time, the probation department felt that you were non-compliant, they would file a written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney at that hearing. If the outcome of that hearing was you failed to comply, then at that time, the court could revoke your community control and then sentence you to a term of incarceration of 6 to 12 months, fine you $2,500. And if your community control were terminated because you committed a new felony offense, then if you were to be sentenced to prison in both this case and the new case, those sentences could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes.
Right now, the charge in this case alleges that on or about September 2, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance to a fentanyl-related compound. Violation of Section 2925.11 of the Ohio Revised Code. So that's the charge of possession of a fentanyl-related compound with the penalties that I've just described. Now, if you, do you understand the nature of those charges, that charge, I should say, and the penalty, the possible,
Yes.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with her advice and competence in this matter?
Yes.
Now, are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, on page 2, there is a statement and printed in bold and underlined that reads, defendant will enter a plea of guilty to the indictment, state defense jointly recommend community control, and a referral to drug court. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No.
Under the law, Ms. Hornsby, the matter of sentence is up to the court. So even though there's an agreement as to what the sentence should be, if you plead guilty, the court does not have to follow that recommendation. I could decide that you should receive a term of incarceration, fine of $2,500, and a license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
All right. Now, you don't hold any license or certification for any job, any kind of profession or occupation that's regulated by the state, do you?
No, sir.
All right. Now, you have a right, have constitutional rights to misunderstand before I can accept your plea. First of all, you have a right to have counsel. Ms. Witt was appointed to represent you. Now, that appointment wasn't simply to work the case out, but provide any defense that may be available to you under the law that you would like her to provide. So, if you decide you do not want to do this, that you want to defend against the charge, she'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
You have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that are summoned for jury duty on your trial date that reside in Highland County. After 12 of those people were selected, the evidence will be presented, they'd be instructed on the law. Then that jury would have to decide by unanimous verdict, meaning all 12 of them would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means give up in writing, your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning the judge would be the one that would hear the evidence instead of a jury. The judge would apply the law, the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in open court, which means public, in front of you and your attorney and anyone else may be present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence of this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it, except in one situation. If there's a jury trial and you do not testify, the judge does instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at trial at all in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
All right, now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied that you committed any crime, and it exercised or invoked all of the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty. Waives gives up your right to a jury or a court trial. The waives gives up your right to confront the witnesses against you and to cross-examine them through your attorney. The waives gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives or gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up all the rights it waives or gives up your right to file an appeal in this matter. Now, you do have a right to file an appeal if I sentence you to the maximum sentence or under other certain limited circumstances. But with that exception, your plea of guilty would waive all of the other rights to appeal, as well as the others that I've just explained. Do you understand all that?
Yes.
Now, are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalties?
No, sir.
You understand them?
Yes.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes.
You have any questions about the constitutional rights that I've explained to you?
No, sir.
You understand those?
Yes, sir.
Is there anything that you would like to speak with Ms. Witt about before we go any further?
No, sir.
You have any questions at all about the charge or the rights or anything that I've explained to you here today?
No, sir.
Then is it your decision to withdraw your not guilty plea and enter a plea of guilty to the charge pursuant to the terms of this written plea agreement that we've just gone over?
Yes, sir.
All right. Then, as to the charge that alleges that on or about September 2, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, fentanyl-related compound, in violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony carrying a possible term of incarceration of 6 to 12 months, fine of $2,500, possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right. The court finds that on this day in open court, the defendant was advised of all her constitutional rights, made a knowing, intelligent, voluntary waiver of those rights pursuant to Criminal Rule 11. Plea is accepted and ordered filed. The defendant is found guilty of the charge. Now, counsel, Ms. Hornsby was just recently before the court, and she was put into the STAR program and has continued, and her probation was continued. Is there any reason to order an update of that, or both parties in agreement that we can proceed without that?
We can proceed, Your Honor.
We are in agreement also, Your Honor.
All right. Now, I see that Ms. Hornsby has filled out an acknowledgement of the drug court program description. And I have a letter from Ms. Sturgill stating that she does meet the criteria at this time, if that is what she would like to do. All right, now, regarding the matter of sentence, Mr. King, anything you would like to say?
Only was King, please read your order.
All right, Ms. Witt?
Yes, Your Honor, we also have support to follow the joint recommendation. As you're aware of, Lindsay completed STAR last week and is at TCC now and has been compliant. And in speaking with her, she is looking forward to drug court and the support system and everything it has to offer so she can maintain her sobriety.
All right, Ms. Hornsby, anything you would like to say?
No, sir.
Well, now, Ms. Hornsby, I don't know to what details explained to you previously, but under the law, I don't order people to go into drug court. They are screened, and then they have to request to be admitted. And the reason for that is because this program is much more intensive than the other program you're under. The focus of it is to try to provide as many tools as possible that will allow someone to totally rebuild their life and become sober. And if they stay sober, they won't likely get into trouble, whereas regular probation or community control is simply to try to help keep you out. So you've gone through the program requirements. You understand what will be required.
Yes, sir.
All right. And is that what you want to do?
Yes, sir.
All right. And you want to do that for both cases?
Yes.
All right. Well, then it is the order of the court that the defendant's request to be admitted into the drug court docket is granted in this case as well as in case number 22 CR 031 for which she's on community control at this time. It's ordered that the defendant be sentenced to a term of 3 years of community control supervision in the drug court docket, and she has complied with all of the conditions that are set forth in that program description and attachments, which she has previously been provided and has acknowledged in written acknowledgments filed with the court. I'm going to go over some of those, Ms. Hornsby, just to highlight them, but everything that you sign and all of the things that are in the program description, you'll have to complete and comply with, including your treatment plan. Now, you're to obey all laws, all jurisdictions, conduct yourself in law-abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department, keep them informed of your residence, place, and employment at all times. You may not change either without prior permission. You can't leave the state of Ohio at any time without prior written permission. You must have that pass with you when you do go out of state. You're not permitted to enter upon the grounds of any correctional facility or to communicate or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. Now, because of your conviction, you're not permitted under either federal or state law to purchase, possess, own, use, or have in your control a firearm, ammunition, or dangerous ordnance, and that's a condition of this order as well as any other weapons are prohibited. You're not permitted to purchase, possess, use, or have under your control a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of a controlled substance, drug abuse that has effects similar to those. You're not permitted to have an instrument, device, or thing that may be used to administer drugs or prepare them for administration unless you have a lawful prescription both for the drug as well as the device or equipment. If you do have a lawful prescription, you must provide a copy of that within 24 hours of receipt. You're may not obtain a medical marijuana card while on the drug court docket, and you must submit to drug testing when and as directed. You're not permitted to purchase, possess, use, have under your control any kind of alcoholic beverage, nor may you be present in places where those are sold or being consumed, even if it's otherwise lawful. You're not to associate with anyone who is a co-defendant in this case or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, nor any other person who has a criminal record. And that applies to any family members other than those with whom you were living immediately before the commission of this offense. Now, after the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any arrest or citation, conviction, or other charge of violating the law not later than or any contact with law enforcement not later than the next business day after that occurs. You must provide your financial information records so your ability to pay any fees, fines, or costs can be reviewed. If you're referred by the probation department for any evaluation or assessment for any further treatment, therapy, counseling, training, and other educational programming. You'll submit to that, and if there's any recommendation for any programming, you're to enroll in and successfully complete that. You'll be required to pay court costs to make payment arrangements with the clerk to do that. And as I said, you'll have to comply with all the conditions of the drug court docket and your treatment plan as recommended. By being placed on community control, rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place that's under your control at any place where you're found by any officer of the probation department. There'll not be any fine or suspension of license imposed. Now, you're also ordered to pay the court cost as a substantive order, and if you don't do that, we'll make payment according to a payment plan that you've entered into. Then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court can require you to do community service in this county and be given credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, then the probation department will notify you in writing and file a copy of that with the court. There will be a hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control and sentence you to a term of incarceration of 6 to 12 months, as I said, and fine you $2,500. If that occurs because you have violated another felony law and been convicted of that, if you're sentenced to prison in that case, then those sentences could be ordered to be served consecutively, meaning one after the other. If you do serve a prison term, upon completion of that, it is possible the Adult Parole Authority will place you under post-release control under the statutory authority they have for these types of offenses, and that could be for up to 2 years. To do that, you'll be supervised on the terms they set. If during that period of time you're being supervised, they determine that you've not complied, then they could return you to prison to make you serve an additional period of up to half of the prison term for one or more violations. But if you're convicted of a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
All right, that concludes your case. You're now under the condition I just went over. The probation department and treatment team will be in touch with you. And I believe we have our next drug court in 2 weeks on a Friday. All right, thank you. All right. Ben, need about 20 copies of those. I've only got 3 left. I got 2 left. I got enough. All right, are you James Laufin appearing there from James E. Laufin appearing there from the jail?
Yes, sir.
All right, this is case number 23 CR 211, State of Ohio versus James E. Laufin. Mr. Laufin is in custody from the jail. It's being this hearing or this notification being conducted by Zoom. Mr. Laufin, you were placed on community control on February the 15th of this year on the charge of receiving stolen property of 4th-degree felony. The court received notice that you had left from that facility and had not reported probation or the jail, so a capias was issued for your arrest, and it looks like you were taken into custody on the 8th. Now, the probation department then has filed a notification that you have failed to comply with the conditions of community control. Ben, where's that? Oh, here it is, game loose. All right, and that was filed, it looks like, on the 8th. It alleges that you violated Rule 19A, that you are required to comply with substance use disorder treatment at the counseling center, and it indicates that you have failed to complete the treatment as directed. Now, you're entitled to have a hearing on this matter, and you're entitled to have an attorney to represent you. And I see that you have filled out a financial disclosure form. Is everything on that form correct?
Yes, sir.
All right. The court then will appoint Mr. Wagner to represent you. We'll set an evidentiary hearing on this matter for March the 18th. At 9 a.m.
Yes, sir.
You'll be held without bond until that time, and we'll notify Mr. Wagner of his appointment.
Thank
Yep.
you for your time, sir.
You have any questions?
One question, sir. Did my lawyer receive my judgment entry from Hamilton County because I was originally...
I have no clue. I wouldn't know.
Okay.
You'd have to ask him that. All right. Thank you. All right, are you David Bailey there at the jail?
Yes, Your Honor.
All right. And Deputy, Mr. Blosser's now signed in, so if you could get Mr. Stratton next, then we'll do his bond review. All right, this is case number 23 CR 148, State of Ohio versus David M. Bailey. This is a notification being conducted by Zoom. Mr. Bailey's in the custody of the sheriff. Mr. Bailey was placed on community control for breaking and entering a 5th-degree felony on October the 4th of last year. Now, Mr. King, has the alleged victim of the offense been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, he has, Your Honor. He is not present today.
All right. All right. Now, that offense that you're on probation for, community control, is a 5th-degree felony, Mr. Bailey, which carries a possible term of incarceration 6 to 12 months and a fine of $2,500. You are entitled to have a hearing on this matter, and if you cannot afford to hire one, the court will appoint one for you. I see you filled out a financial disclosure form. Is everything on this form correct?
Yes, sir, Your Honor.
All right. Court then will appoint Attorney Danielle Witt to represent you. Also, I didn't read you the allegations, but the allegations that you failed to comply were filed on March 5th, alleges you violated Rule 2 that on or after 11/4/23 you failed to report, and Rule 13 on November 4, 2023 you left residential treatment at the counseling center and didn't report to the probation department nor to the jail. So those are the allegations against you. We will set your hearing for Monday, March the 18th at 9:15 a.m. And you'll be held without bond until that time. We'll notify your attorney. Do you have any questions?
No, sir.
All right, thank you.
Thank you very much. Hello, sir.
Good afternoon, Are you Waylon Stratton?
Yes, sir.
All right. This is case number 24 CR 43, State of Ohio versus Waylon James Stratton. This is a bond review hearing. It's being conducted by Zoom. Mr. Stratton is in the custody of the Sheriff's Department. He was arraigned last week, and in the absence of counsel, bond was set, and so pursuant to statute, the court's conducting this review of the bond order. He is indicted on 5 counts of rape, first-degree felonies. All right, Mr. Stratton's attorney is Jeffrey Blosser, appearing on his iPhone, and appearing on behalf of the state from his office is Assistant Prosecuting Attorney King. Mr. Blosser, you wish to address the matter of bond?
Yes, Your Honor. First off, I received a notice of appointment late Friday afternoon. Thank you. We were able to get a file at least set up. I am concluding a bench trial right now, and we'll probably have the discovery demand and bill of particulars motion done, if not this afternoon, first thing tomorrow morning. There's been some information conveyed to me from my service from Mr. Stratton's family. However, nothing that I can confirm. If we're able to confirm anything, we will file a separate motion to address the bond issue.
All right. Mr. King, anything you'd like to say?
No, Your Honor.
Well, the court's original bond of $100,000 cash real estate surety, plus the conditions of pretrial supervision will remain in effect. Of course, at any time, if there's new information brought before the court, the matter would be heard. Thank you, Mr. Blosser.
Thank you, Your Honor.
Hey, remind me, I want to see that Lindsay Hornsby pre-sentence investigation. Let's see. Oh, I had another copy of that. Oh, okay. That's what I did with it. Didn't have it. All right, are you Stephen J. Walker there at the jail? All right. It's case number 17, CR 124, State of Ohio versus Stephen J. Walker. Mr. Walker is in custody, so this hearing is being conducted by Zoom. The Assistant Prosecutor, Adam King, is present for the state. And has the actual victim, in this case, since there's been a conviction, been notified of the time, place, and purpose of this hearing and right to be heard, Mr. King?
Your Honor, the state has notified the Child Support Enforcement Agency, and there is no victim or victim represented present today at this time.
Okay. All right. Mr. Walker, you were convicted of non-support and put on community control back on August 17th, I believe, of 2022. And yeah, August 17th, 2022. And it looks like there was a warrant issued for your arrest on October 17th, 2022. And you've been taken into custody on that warrant, it looks like back on March the 6th. We have a notification on this, Ben? We do, don't we? Yeah. Miss Walker, or Miss Kelly is the officer. Mr. Breeden, do we have a written notification on this, or is I'm having trouble finding it?
Let me check real quick, Your Honor.
That's a capious entry. You want to go back and check and see if it's in there? Maybe check these files, see if they got. Pardon me? Oh, Mr. Yeah, don't say anything, Mr. Walker. I thought that was the probation officer. I didn't hear what you said, so it doesn't matter. He has? All right, so why are we doing this then? All right. Well, Mr. Bailey, Mr. Walker, we don't have a notification yet, according to the bailiff. So you'll remain in jail, and as soon as we get, hopefully we'll get one today or tomorrow, and we'll notify you then. All right? So you can step out. Thank you.
What is that?
Pardon me?
What is that?
What is what?
Okay,
The written notification from the probation department alleging that you have violated the terms of community control. We don't have that yet. So as soon as we get it, we'll reschedule your hearing. Okay? Thank you.
it's here.
I don't have it. That's what I'm telling you. And my bailiff just checked, and we don't have it. So
Sorry, Your Honor.
that's not your fault. We don't have it. And that, well,
They're supposed to transfer my parole down there, and they never did.
that doesn't matter. The probation violation, you know what, just be quiet, because you can't do anything to help yourself here, okay? So just step out of the room.
Yes,
All right, Mr. King, are you going to handle the arraignments?
Yes, I'll be right
All right, come on over. All right, this is case number 24CR047, State of Ohio versus Tiffany L. Watson Battinghouse. And are you Tiffany L. Watson Battinghouse? Is that how you pronounce that, Battinghouse or Batinghouse? With a hard A? Okay, thank you. Ms. Batinghouse is appearing from the Justice Center. She's in custody. She's appearing by Zoom. And this matter was set for an arraignment after she was turned herself in this morning to the Sheriff's Department. Her attorney is William Parker of Cincinnati. He is present in the courtroom. And then representing the state also in the courtroom is Assistant Prosecuting Attorney Adam King. The defendant is charged with co-defendant. She's charged in counts 2 through 4. 2 counts of disseminating matter harmful to juveniles, 4th-degree felony, 1 count of endangering children, a 2nd-degree felony, and 1 count of endangering children, a 3rd-degree felony. Mr. King has a representative of the alleged victim been notified of the time, place, and purpose of this hearing, the right to be present and be
Yes,
heard?
Your Honor, and the representative is present in the courtroom today.
All right, and who is that person?
It's a grandmother and grandfather, Your Honor.
All right. All right, Mr. Parker, have you received a copy of the indictment?
I haven't, Your Honor, but on behalf of Ms. Watson, if she hasn't been served, we would waive service of the indictment and a formal reading at this time, and her not guilty plea.
And you waive the 24-hour waiting period as well?
Yes, Your Honor.
Thank you. And do you wish to have the indictment read, or
No, Your Honor.
How does
We
your client
waive a
plead?
formal reading at this time.
not guilty?
Not guilty plea, Your Honor.
All right. All right, the court will set a pretrial in this matter for April the 3rd at 1:30 p.m. That can be by Zoom, Mr. Parker.
Your Honor, I apologize. I'm actually in a jury trial that day.
All right.
Another day that might work for the court's calendar.
What about the 4th?
Yes, Your Honor, I'll be available.
All right, so then it'll be April the 4th at 1 p.m. then.
Thank you, Your
And
Honor.
that'll be by Zoom. Final pretrial, May the 1st.
Your Honor, I'm also in
You
a
also
jury
bit-
trial. I'm in a jury trial that day, but it looks like the Thursday and Friday, the 2nd or 3rd.
May 2nd?
Yes, Your Honor.
All right,
Thank
so
you.
May 2nd at 1 o'clock. And that also can be by Zoom if you wish, or in person, whichever you prefer. And then the jury trial, June the 10th. Is that clear on your calendar?
It is, Your Honor. If I could just ask, Mr. Weiswork, is that on your calendar as well?
That works. Thank you.
All right. That'll be at 8 a.m. All right, now, with regard to bond, Mr. King, on behalf of the state, anything you'd like to offer?
Only was included in the bond recommendation sheet, Your Honor.
I haven't looked. 40,000?
Yes, sir.
All right. Does the representative of the alleged victim wish to be heard
No,
regarding
Your
bond?
Honor.
Pardon me?
No, Your Honor.
All right. Mr. Parker?
Just briefly, Your Honor, I know that Ms. Watson works at Kroger. She was just recently promoted to a management position. She's nearly 37 years of age. I'm not aware of any prior criminal history. And importantly, she turned herself in expeditiously, I might add. She was notified of this Thursday afternoon, retained counsel Friday afternoon, and then turned herself in this Monday morning. So based upon that, Your Honor, we would ask the court to consider a low cash professional bond at 10% to the court. She'll follow any and all conditions the court would impose upon her, including no contact with juveniles or any other conditions the court may find appropriate.
Now, the child that, is it one child that's alleged victim in
Yes, Your Honor.
both counts,
Yes,
all 4 counts? 2, 3, and 4, or 5?
that's correct.
All right, how old is that child? 7 to 10 years, it looks like? Count 5? Well, that was in 2020 to 2023, so it would have
11 years old, Your
be
Honor.
11 years old now, looks like birthday was in 13. All right. And what's the relationship with the alleged victim?
This defendant is the mother and the co-defendant is the stepfather.
All right. We'll set bond in the amount of $20,000 plus OR, which is your promise to appear, ma'am, and if you fail to appear, you could be prosecuted for an additional felony and convicted, sentenced on that, no matter what happens in this case. You'll be required to pay a deposit for certain statutorily required fees of $161 prior to release, $116. If you do make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You must report to them immediately upon your release from custody. And you'll be required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing, provide phone numbers for home, cell, employer, not to have any contact with the alleged victim, any family members, or any child under 18. Not to have any contact with your co-defendant. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If they recommend any treatment, you're to enroll in and file that during the pendency of the action. You'll also be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of schooling, job training, educational programming, etc., or church services. Other than that, you have to be there at all times. And if you fail to comply, then you could be taken into custody and have your bond terminated until further order of the court. All right.
Your Honor, if
Yes.
I could just address the no contact with co-defendant. These two are married and they reside in the same home. I understand it's the court's normal procedure to have no contact, but given they are married and reside in the same home, would the court consider lifting that condition?
No, not under the circumstances of the allegations in this case. They'll have to live separate and apart.
Thank you, Your Honor.
All right. Anything further?
No, Your Honor.
All right. Thank you. You bring in Andrew. Your last name, W-E-I?
W-I-E, Judge.
I-E.
C.
I before E except after C.
C-Z-O-R-E-K. We filed a notice.
W-I-E-Z.
C-Z.
C-Z.
O-R-E-K.
Okay.
Thank you.
All right. And you're in, I know you guys are in Batavia.
No, Cincinnati.
Is that a Cincinnati address where you're at?
It is, yes, sir.
Okay, thank you. I've been by your office, but what is it, it's close, is it between New Richmond and Batavia?
No, our offices are in the Hyde Park, Mount Lookout area.
Oh, okay.
Yeah, Oakley area. somewhere.
Didn't Bill used to have an address up there?
Yeah, Bill has an office in Batavia. I work
Oh, okay,
as
that's
a
where his
counsel
office
with
is.
him. Yeah,
I
two
got you.
separate offices.
I got you.
Thank you.
All right, are you Andrew Lee Watson? All right, this is case number 24CR046, State of Ohio versus Andrew L. Watson. Mr. Watson's appearing by video from the jail. He's in the custody there by Zoom. His attorney, Mark Weiserick, is present in the courtroom, and representing the state is Assistant Prosecutor Adam King. Defendant is charged with gross sexual imposition, a third-degree felony, 2 counts of disseminating matter harmful to juveniles, 4th-degree felonies, 1 count of endangering children, a second-degree felony, and 1 count of endangering children, a third-degree felony. Now, Mr. King is A representative of the alleged victim of the offense has been notified of the time, place, and purpose of this hearing, the right to be heard.
Yes, Your Honor. The grandparents of the alleged victim are present in the courtroom today.
All right. All right, now, Mr. Weisrick, have you had an opportunity to have a copy of the bill or of the indictment yet?
No, Your Honor. Respectfully, we have not received a copy of the indictment. However, we would waive its reading, we'll waive any defects associated with it, waive the 24-hour rule, and waive its reading in open court, enter initial plea of not guilty.
All right, thank you. All right, then, set the first pretrial on April the, you want to do the 3rd or the 4th, Mr. Weisrick, whichever one's available to you?
Is the co-defendant set on the 4th?
Yeah,
The 4th works, Judge.
all right, so that'd be at 1 o'clock, and that can be Mizoom.
Thank
And
you.
then, final pretrial then would be the 2nd of May.
Judge, on that, we're starting a capital murder case on April 29th. If we could just advance that 1 week,
Okay.
either April 22nd or 23rd would be fine.
All right, let me look here. Well, yeah, I'll be, wait a minute, the 22nd is a Monday, right?
It is.
Yeah, I'll be here. I get back from a trip on Sunday, and then the next 2-3 days after that, I have to be in Columbus, so the 22nd would be all right.
Thank you.
So we'll do that April the 22nd at 1 o'clock.
Would that be by Zoom as
It
well?
can be, yes.
Thank you.
All right, and then the trial date, I believe you confirmed that with the co-defendant that June the 10th is available.
That's correct.
All right. So at this time, they'll be set for joint trial unless they're both joined in the indictment. So if there's a motion to sever, then we'll address that.
Very well.
All right, Mr. King, on behalf of the state, anything regarding bond?
Only was contained in the bond recommendation sheet, Your Honor.
Does the representative of the alleged victim wish to be heard on that?
No, sir.
All right. Mr. Weisrick?
Thank you, Your Honor. As it relates to Mr. Watson, he's got a very limited criminal record, if anything, at all. No failures to appear. We'd be submitting on the same argument that Mr. Parker made in conjunction with the co-defendant. We would just ask for a nominal bond that would be set for the same amount, cash surety or 10%, to be in parity with the co-defendant, Ms. Tiffany Watson. Thank you.
You mentioned he has a limited criminal record. What criminal record are you aware of? Because we ran him through court network, and the bailiff can't get him under either name or SSN or date of birth.
Your Honor, I'm not aware of any at this time. However, until we go through and do the formal discovery, I won't necessarily stand on that as being 100% accurate, but
Have any leads or anything that shows him in the system? Because, like I said, the Ohio Court Networks doesn't have anything on him that we're able to pull out. Sometimes there's a glitch, but right now, the bailiff ran it 3 different ways and couldn't get it any of those 3 ways.
I see a traffic offense in Washington Courthouse back in 2013. I'm not seeing any criminal history for this defendant, Your Honor.
All right. Well, after the hearing, I don't want to do it while we're on record. If you would give the bailiff your information on his date of birth and social security so we can run it again and see if we can get it out of the network, court network. All right. And is the alleged victim of count 1 the same as in the other 4 counts?
Yes, Your Honor.
And I think you said in the last hearing that he is the stepfather of the alleged victim.
That's correct, Your Honor.
All right. Well, given the nature of these charges, the court is going to set bond in the amount of $50,000 plus OR, which is your promise to appear, Mr. Watson, if you make bond. And if you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that, regardless of what happens in this case, you'll be required to pay a deposit of $116 for certain statutorily required fees. If you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You're to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, and employer, have no contact with the alleged victim, any family member, or any child under 18. You not to have any contact with the co-defendant. If recommended by probation, you'll be evaluated for substance abuse, for mental health issues, and if any treatment is recommended, you'll enroll in and follow that during the pendency of the action. And you'll be under house arrest at your residence, meaning you have to be there at all times, unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. Appointments with an attorney in this or any other case. You can attend any kind of job training, schooling, educational programming of any type, classes, etc., or church services. Other than that, you have to be there at all times. All right. Anything further, counsel?
No, Your Honor.
Judge asked the court to consider a 10% requirement on that.
We don't do 10%.
Very well. Thank you.
Thank you.